Well, good morning, everyone. We'll just wait a few seconds to make sure everyone has settled in. Okay, so I think we can begin. Good morning, everyone. Thank you for joining our webinar this morning. I have one initial question where to make sure to check if we are going to do this in English or in Portuguese. So I'm going to ask you if there's anyone that is an English speaker, if you could please, just open your audio and say something to us or write something in the chat, just to check if we have any English speakers. So if we have, we'll continue in English. That's totally fine. Otherwise, we might switch to Portuguese. So I'm going to wait a few seconds so you can let us know.
An English speaker.
Okay, so we have an English speaker. That's fine. So we'll continue this in English. Good morning again. Thank you all for joining us for this webinar. We are very happy. Me and Maria, we are the co-chairs of the Brazil chapter of NYSBA's international section. We are hosting this event, and we are very thankful to have our friends, Tiffany, David, and Nair, David from Allen Overy, Tiffany and Nair from Madrona Fialho. And we're going to have a wonderful discussion today about conflicts of interest of shareholders in companies, which is always a fascinating theme. Very happy to be participating in this discussion. So, a quick word about NYSBA. So NYSBA is one of it's the New York State Bar Association. It's one of the biggest law associations in the U.S. And we have a presence in almost 20 countries around the world through the international section. And we have a lot of activities. We host events. We have networking sessions. If you are a member of NYSBA, we have access to lawyers all around the world. You have access to referrals, and you can communicate. You can engage with lawyers not only from New York but also from around the world. So if you have any interest, you can check NYSBA's website. You can write to us, and we'll be very happy to talk to you and let you know and tell more about NYSBA. So let me give the floor to Maria, and then we can begin.
Hi, good morning, everyone. Thank you for joining us on this event. I'd like to thank you, Nair, Tiffany, and David for putting together such an interesting panel. And just wish you all a good session here. We will follow up here if you have any questions and answers, questions for us to answer. And thank you, and have a good event. Nair, David, Tiffany, the floor is yours.
Thank you so much. Thank you, Cauê. Thank you, Maria. And good morning, everyone. First, why we brought this issue to discuss with you, conflicts of interest in shareholders resolutions. Because CVM, the Brazilian Securities Commission, had an important decision, in fact, two decisions on last November 2022. It was on the cases of Springer and Saraiva, and they had a shift on their previous understanding of the matter and how they apply the theories of conflicts of interests in shareholders meetings. So we have basically two theories. One, the name in Portuguese is teoria formal, which is, I can translate like presumed damage theory, and the other one is teoria material. I can call it proved damage theory. Oh, sorry, I have a PowerPoint. One moment. Let me only share with you. That will be easier for everyone to follow me. Tiffany, can you help me with this? Because it was supposed to be open and available here, but I can't find. I don't know why. Thank you so much. So next slide, please. Okay, next one, please. Yes, and no, sorry, the previous one, based in teoria formal, presumed damage theory, in case you identified a conflict between the shareholder and the company, this shareholder shall refrain from voting, cannot vote. And based in teoria material, in case you have a potential conflict of interests between the shareholder and the company, the shareholder is allowed to vote. And in case there are damages caused by this vote, you can annul the resolution, and the shareholder will have to indemnify the company. Okay. Next, please. During the last 20 years, and more strongly in the last 10 years, CVM has applied the formal theory. What means that in case there was a potential conflict between interests of the shareholders and the company, the shareholder should not vote. And in case it decides to vote, in spite of that, it would be subject to penalties from the CVM. Okay. And now what changed is that the element damage became a fundamental element to characterize the conflict. We don't talk about, more about potential conflict. Okay, or you have a conflict and this is materialized, is demonstrated by losses, or you don't have a conflict at all. Can go ahead, please, Tiffany. We have some interesting learnings. We learned something interesting from this decision, two very interesting things from this decision. And one is this first conclusion that we got here. This division, the frontiers between conflito formal and conflito material, and if I understand that it has disappeared. Why? Because if you analyze the votes of each member of the CVM board, you will see that we have the vote of Flávia Perlingueiro, who is she lost because there was 5 votes, 4 in favor and 1 against, and she lost in her vote. But what does she say? What does she say? She says that she's in favor historically for years, for decades, in favor of the formal conflict. However, in the end of her vote, he says that notwithstanding everything that I have said, in case you have not all agreements between the company and a shareholder shall be considered a conflicting agreement. What means that? She has this flexibility, makes us understand that not always the shareholder shall refrain from voting in case of conflicts of interest, based in the formal theory. And then when you go to the ones who argue in favor of the teoria material, and João Scioli is in favor of it very strongly and for a lot of years, and he said also that only stating it again for you to understand, when we have teoria material is what you have, you are allowed to vote, and in case you have damages, you have to indemnify the company and the resolution may be annulled. Okay, but what does he say in the end of his vote? He says that in case you can anticipate that vote in that way will cause damages, you should refrain from voting as well. So we are talking, we don't have more any frontiers between formal theory and material theory, in my view. We have only, it's the next slide, please, Tiffany. We have only to analyze whether or not that vote will cause damage. In case you have clear elements to anticipate that this vote will cause damages, you should refrain from voting. And but you are always allowed to vote, okay? You are allowed to vote, but you are going to be subject to indemnification, and the decision may be, the resolution may be annulled in case the damages are demonstrated. Okay, one more, please, Tiffany. And another element that we understood that is very important on CVM analysis on this matter is the governance, because there is, it's very difficult, I think, not only in Brazil, in US, David can tell us that, to demonstrate, in most of the times, it's very difficult and maybe impossible sometimes to demonstrate the damage. Of course, you have huge scandals in these cases. Of course, it's easy to demonstrate, but in most of the cases, it's very difficult to demonstrate. For example, you have a controlling shareholder who is a global player on the telecommunication sector, and it executes an agreement, a very strategic agreement with a company, with the Brazilian company, under which it transfers know-how, and how can you say, it's not easy to say that this agreement was the best one to be made with the Brazilian company, was very good, and also for the CVM. So how a shareholder should protect itself from this situation. For any shareholder can go to the CVM and say, oh, this is causing damage to the company, and CVM we're going to analyze that. How you can protect itself? It maybe depends on the case. Okay, it's not there is no recipe for all the cases, and depends on the nature and the size of the transaction, the situation that you're analyzing here. Depends on the structure of the governance of each company, but maybe it should be interesting to get an independent third party's opinion, or maybe you should submit to a prior approval of your related parties transaction, or a corporate governance committee. I mean, you should submit to the committees that you have or that are entitled to analyze this kind of situation, or at least for the independent members of the board of directors. Depends on the case of each company and the object of analysis here. But if you take a few time to read these two decisions, and I suggest you do that, you're going to see how relevant the governance is for the CVM analysis in these cases. Okay, this is something concrete, something, and it shows transparency from the shareholders, so it's extremely positive. And another point that, Chief, and I think we can go to the next one. Another point that I'd like to raise here, and I'm really curious to hear from David on that as well, how it works in US, is that assuming that there is a situation, a matter where you can anticipate that will cause damages to the company, a conflicting agreement, and based on the information that the company has to release to the shareholders before the meeting, in relation to that matter, you can clearly anticipate that this will be really harmful for the company, will cause damages. What can be done? First, it's important to say that it's open to the shareholder to decide whether he will vote or not. The chairman of the meeting does not have authority on that, does not have this power. Okay, so this is, of course, you can always go and try to get an order, a judicial order or something like that, an arbitral order, but in a regular basis, the shareholder is entitled to decide. What the chairman can do, in fact, the chairman, we are going to talk about this in the next slides, he should disregard votes cast by shareholders against express legal provisions. We have a few provisions in Brazilian corporate law where the shareholders cannot vote and simple like that. And in this, and only in these cases, the chairman of the meeting can disregard these votes. And an interesting comment here also. CVM understands that it cannot penalize the chairman of the meeting for anything he does during the meeting because he acts by delegation of the shareholders, and it is supposed to rule the shareholders and fiscalize and penalize the shareholders, but not the chairman of the shareholders meeting. Okay, it's another element only to bear in mind. Next, please, Tiffany. Here are some examples of what we have in the Brazilian corporate law, some cases in which the shareholder is prohibited to vote. For example, the classic one is this: to approve its own accounts. It's easy to understand why a shareholder could not approve its own accounts, but and in case he goes to the meeting and vote on that, and in case he votes on that, the chairman of the meeting shall disregard his vote. Another example, also here, to vote in appraisal report for evaluation of their own assets, the assets they are contributing to the corporate capital as well. And shareholders agreements, agreements, for example, if you have a shareholders agreement with a pooling agreement, what means that all decisions of the controlling block, the controlling group, is taken in a previous meeting before the general meeting. In such a case, you're going to have minutes of this previous resolution, previous meeting, and a proxy of this pool of controlling shareholders will be the only one entitled to vote in the meeting. Okay, so in case you do that and you have a pooling agreement and this proxy goes to the meeting and votes in a specific direction, and then one of the members of the controlling group shows up in the meeting and say, I changed my mind, I want to vote. He cannot vote, okay, because he has already voted. So the proxy is the only one who can vote here. So in this case, the chairman is allowed and also he has to ignore this vote from the controlling shareholder himself. And in case of super voting shares, you have in super voting shares that sunset clause based in which, for example, in a certain company, they imagine that they have super voting shares, and based according to Brazilian law, it shall last a maximum first period of 7 years. After this first period of 7 years, the super voting share become a regular share. Except a regular share, it means not 10 or 20 votes per share, but only 1 vote per share. Except if there is a resolution by the shareholders, but not by all of them, only by the majority of the minority shareholders. that approving that these super voting shares shall be valid for more 20 years, for example. And then the holders of the super voting shares shall refrain from voting. And in case they decide to vote, this vote shall not be registered by the chairman of the meeting, okay? I think go ahead, Tiffany, I think it's all. Yes, that's all. So these are the overview that I would like to share with you. And I want to hear from David how it works in US, particularly in the critical points raised here. Please, David, go ahead.
Thank you so much, Nair. It's great to see everybody this morning. Thanks so much to the team, the New York State Bar Association, for the invitation, and Kawe and Maria de Paz. It's really wonderful to be here with you. One of the things that I love about practicing corporate finance, capital markets law on a cross-border basis is that our regimes can really evolve in very different ways. And hearing about this development of the CVM and the interpretation of the teorías on conflicts of interest is really fascinating in many ways, because it's clear that the CVM is steering the market and explaining to, in particular, public company shareholders where they may face challenges in exercising their vote and considering what a conflict of interest is. I thought I would use some of this time just to talk a little bit about how different our system is and how, in many ways, some of the considerations Nair was presenting apply or will apply a bit differently. And maybe actually for the group, if there are questions either about the kind of the Brazilian evolution here, some ways that we're thinking about this in the US, will converge. It'd be nice to hear from others who are here on the line. So it's great that we have a really nice audience today. I thought I'd start by actually just framing the way that we think about things in U.S. corporate law, which is quite different from the way that we think about things in Brazilian corporate law. And because my practice is typically working with Brazilian companies who are in the U.S. market with a stock exchange listing, and so registered with the U.S. Securities and Exchange Commission, the U.S. CVM, we need to be thinking about how our framework applies and how U.S. shareholders, for example, think about their rights when they look at Brazilian companies. And then a lot of times their reference is U.S. investors is what we have in the U.S. And what we think about in the U.S. in terms of shareholder protections and shareholder obligations and responsibilities. The U.S., obviously, we have 50 states and we have different regimes that apply, and we are, as a common law system, much more reliant on jurisprudence from courts and how courts are interpreting statutes and laws over time. And so we don't look at the civil law development in Brazil in the same way. It's quite interesting to hear how this evolution in the interpretation from a regulator like the CVM of how these theories of conflicts of interest should be applied, what decisions can be made at the shareholder level. Because Delaware corporate law is so prevalent, and Delaware corporate law, especially as it relates to shareholder rights, really is, say, a guiding body of law. We really look to Delaware law most regularly, as well as the decisions of the Delaware Chancery Court and Delaware Supreme Court, to tell us how shareholder rights really work in practice. There's a whole system in the U.S. That is regulated by our CVM, by the SEC, when it comes to proxies. And proxy voting is really a regime that U.S. domestic companies have to follow very carefully and wisely. Most of that is similar to other SEC rules that relate to disclosure, but it also obviously relates to how the proxies are voted in the context of a shareholders meeting. What I thought I'd emphasize, though, is really the Delaware corporate law issues, because proxy rules are really a bit more administrative, and they're mostly about disclosure and transparency, a little bit less about how to apply governance standards and duties of care, duties of loyalty, and other fiduciary duties, which are really litigated at the kind of state corporate law level. So I thought I'd actually kind of try to address this by thinking a little bit about how shareholders behave in Delaware corporations, how they need to behave, what their role is. And we have a very clear distinction when it comes to conflicts of interest and thinking about, well, who's voting, right? Are we thinking about directors and officers? In this context for today, we're really just focused on the shareholders and how shareholders are approving decisions and whether they may need to recuse themselves with a conflict of interest. And for that determination, one of the current areas of real obsession in the U.S. market, because shareholder activism has become so prominent, is who is this shareholder? Is it a controlling shareholder? Is it a minority shareholder? What do those different statuses really require? So in the context of a shareholder vote, when we think about conflicts of interest, we have to think about who that shareholder is, whether that shareholder might be categorized as either a controlling shareholder or a majority shareholder or a shareholder with significant influence. And there's actually a lot of debate right now. There was just a Harvard Law School, Harvard Law Journal article that was published just 2 years ago, 2 to 3 years ago, on the whole topic of seeing Delaware courts start to give basically additional scrutiny to certain shareholders who are not clearly controlling shareholders and majority shareholders. And the reason that's relevant here is because you're broadening the group of those for whom a conflict of interest could be more scrutinized and challenged. One of the things I wanted to answer Nair directly is that in the context of a shareholders meeting, the chairman, who's typically the chairman of the board of the company, but sometimes could be delegated, doesn't really have very many rights when it comes to exercising discretion. And so there really aren't parameters around a possible selection of votes for which that chairman of the shareholders meeting would say, here's a category of shareholders who are no longer eligible to vote on a particular decision because a conflict of interest has arisen. In practice, as many of you may know, our system, because the companies kind of are so large and typically have so many millions, it could be millions of shareholders actually, but many, many tens of thousands, if not hundreds of thousands of shareholders, oftentimes have very, very carefully orchestrated shareholders meetings that are designed to be automatic. And so the chairman is really showing up, allowing for normal, ordinary, bylaw compliant administrative and ministerial steps to occur, but decisions aren't really made at that shareholders meeting. Typically just the proxy votes are delivered and they are tabulated. One of the big question marks that we're also facing relates to who's actually casting these proxy votes. And because so much of our market is dominated by institutional investors who vote by proxy through ISS or Glass Lewis, which are big proxy advisors, there's a big debate about whether those proxy advisors actually have agency and should be voting in the best interest of the company or not. What if one of those proxy advisors itself has a conflict of interest? And in some cases that has been brought to the fore and discussed. So we have all of these different layers of how Delaware corporate law is still struggling with the reality that shareholders' votes are pretty complicated moments. And that's why I found it so interesting in Nair's discussion here of how the CVM is thinking about whether, certain shareholders may have a conflict of interest. They have to determine whether the decision that they're going to vote on could lead to damages. We don't get there really on the merits of certain of these discussions. The question of eligibility is really going to turn more on duties or lacks of duty, and I can chat about that in just a moment, as opposed to whether that shareholder is going to be taking an active view on whether the decision could have a result in damages for the company. The way that we really think about this kind of majority shareholder or influential shareholder versus minority shareholder dichotomy, to kind of group those two categories, is really important, because if a controlling shareholder has that status, technically speaking, for U.S. law purposes, that controlling shareholder is actually going to have a fiduciary duty to the company itself, as well as to the minority shareholders who are going to be influenced by that decision. That duty of the majority shareholders effectively means that majority shareholder needs to act in the best interest of the corporation and consider the interests of minority shareholders. And there's Delaware jurisprudence around this saying it's fine for majority shareholders to act in their own best interests. That's, again, a question of, well, is there always an inherent conflict of interest for what that majority shareholder wants to do? Think about Elon Musk and Tesla. Elon Musk, as a controlling shareholder of Tesla, has made a whole series of very self-interested decisions in shareholders' meetings, and those have been subjected to scrutiny in the courts. And there are shareholders' lawsuits basically whenever there's a Tesla meeting to approve a strategic decision. In some cases, controlling shareholders like Elon Musk have taken certain steps to disclose information about what they want. In one recent case, it was just a few years ago when Elon Musk had Tesla acquire another Elon Musk owned company for Tesla. And the question is, well, should he have voted on that? Or did he need to actually sit back? And in fact, he was quite careful about ensuring he did not vote on that. He recused himself with a conflict of interest. But even so, there's jurisprudence in Delaware that interprets the statute that would determine who needs to decide on what where, that will really just focus on fairness. And even if Elon Musk were putting that decision forward, he would have to potentially bear a burden of proof that that decision of Elon Musk to put in front of the Tesla shareholders an acquisition of another Elon Musk company was still fair to the company itself and to the minority shareholders. So just to kind of break down those standards, we have different variations across the U.S. states. Delaware, as I said before, is kind of the majority, has a majority kind of view on what happens in conflicts of interest scenarios, who is actually able to vote, and how to actually make sure that that decision in a shareholders meeting can withstand shareholder litigation, right, and allegations that the conflict of interest actually was so predominant it should nullify a particular decision. Ultimately, the statutory standards, in order for a potentially conflicted decision to go through and actually withstand a threat of unwinding and repeal, really would stand on whether there has been full disclosure to the company itself, as well as to a majority of the disinterested board members voting on that decision. That in and of itself could trump a conflict of interest situation. There could be full disclosure to and approval by a majority of disinterested shareholders. And again, that actually is very interesting because they're, back to Nair's point, it's not disinterested shareholders based on what a chairman of the shareholders meeting will determine. Those shareholders need to actually self-identify as interested in a particular transaction, and that itself could be scrutinized by a court after the fact if there's any questioning as to whether there were shareholders who were voting who were actually interested parties. But interestingly, the third prong to overcoming a conflict of interest scenario and approving a conflicted transaction could be just if the transaction is fair to the corporation. And again, that's a legal standard. And the legal standard is very strict to interpret what entire fairness means for a transaction to go forward. What we look at, I think, in the U.S. market, which is quite different from the Brazilian market, is a situation where effectively all of these decisions, if there is a conflict of interest, everyone needs to be thinking about how to make that transaction as bulletproof as possible when it will be subjected to shareholder litigation after the fact. So in some ways, I think the damages analysis that Nair was just describing for us, which is very interesting, and in some ways is something that we always think about. Every decision in a U.S. corporation could be subjected ex post, right after it's made, to a damages assessment. I find it very hard to do that beforehand, ex ante. And there are really interesting parallels I was thinking about when I was looking at this evolution. In the U.S. market, for example, if we think about our antitrust system, right? Our Federal Trade Commission, our FTC, always has to pre-approve a merger or a different strategic transaction beforehand to think about the implications to the market, to the particular organization, to shareholders, et cetera. And in Brazil, dealing with CADE's antitrust determination after a particular transaction would go through was always so strange to me. So when that actually changed in the system of evaluating, well, what's the implication of this from a regulatory perspective, from a market perspective, from a company perspective, and the fact that that could be either ex ante or ex post for the decision, I found very, very interesting and very complicated and very different from the U.S. environment. Oftentimes in the U.S., we're very much focused on assessing what we possibly can, getting regulatory approval, and then letting the market play out however the market's going to play out. In this particular context of conflicts of interest, the U.S. system is really so different from the Brazilian system in the way that the regulators actually think about things. Effectively, regulators don't get in the way oftentimes unless there's really fraud or there's deceit. The SEC gets involved immediately when there are tips or there's information that there's been a material misstatement or an omission of information about a particular vote, for example. So the SEC's standard really focuses more on disclosure and transparency, but the regulator is less involved in in corporate law, is less involved in determining whether a particular individual has a conflict of interest or not. Again, so even if you had an interested shareholder who said, I don't know if I should be able to vote or not here, I think the question about damages is quite important, because that shareholder should always be looking to maximize its own value. Our system just relies on that principle. Shareholders exist really to put their equity into an investment and gain returns, not necessarily taking on any other kind of roles or really subjecting themselves to liability or responsibility. If a shareholder decides in a meeting, especially a minority shareholder, goes forward with a decision, the presumption is always that shareholder will be acting in that shareholder's individual self-interest for one reason or another. And corporate law absolutely does not give that shareholder any responsibility or put on them an obligation to be acting with anybody else's interests in mind or thinking about the potential conflict they may have. That's true, but again, scrutiny is always backward looking. And in hindsight, there are instances, and there's some Delaware corporate law I was looking at, where some shareholders actually had more influence than they realized that they did, or that because, for example, they may have alternative arrangements, they may have contracts that they want a company to sign up to that could benefit their own businesses. And if that's not disclosed, in some cases, some of those types of contracts that may have been ratified in a shareholders meeting could be unwound and subject to scrutiny. Most of our system, just thinking about the teoria formal that Nair was laying out, really, it for us, it just doesn't make sense, and really isn't it's not a doctrinal process, as we think about Delaware corporate law or kind of U.S. corporate law or SEC standards. So I thought with that, I actually wanted to go back to Nair and ask a couple questions maybe about whether we can think about controlling shareholder responsibilities in thinking about these conflicts of interest a little bit differently. Whether in the in the case of some of the decision making, or I guess this change in this sort of aggregation of the theories, whether that's going to lead to just a different structure of shareholder meetings and shareholder votes. What is this maybe going to do from a practical perspective? Again, in the U.S., our biggest concerns these days with shareholder activism is less actually around conflicts of interest that are maybe not disclosed, but really around minority shareholders who might have completely different agendas, and they're acting in their own self-interest, but it's not really about value maximization or minimizing damages, maybe in the context that we've been discussing here. Their votes are less about, let me think about the damage that this may actually lead to. They're thinking about policy considerations, and you're getting these shareholder activists, particularly in the ESG supporting context, who are buying oil and gas company shares, not necessarily to advocate for decision-making that will again, maximize value for these companies, could actually lead to some damages for the companies, meaning a little bit of loss or requiring the company to undertake new compliance requirements. But they're doing so because they're taking kind of a principled view. And they're saying, I'm going to push my agenda as an activist by buying shares and actually changing the governance of a company, which could, again, be in some ways value destroying, because it will lead to more compliance requirements, putting more expenses and costs into the company. That's really, I think, where we're seeing a really interesting debate about how shareholders, how much power shareholders, in particular minority shareholders, should have in the context of voting in these shareholder resolutions.
Let only me understand one thing from you before that. In U.S. experience, for example, you mentioned this decision of this resolution of Elon Musk on his acquisition.
Yes.
He didn't vote, right?
Correct.
But well, think about not this part, any case like that. For example, you have a controlling shareholder, a relevant transaction, and if I understood you correctly, this shareholder should not vote in case there is a potential conflict. And typically it doesn't vote. However, assuming that it decides to vote, what is supposed to happen to him in case it's proved that no damage occurred? For example, you didn't have any damage, but this shareholder voted, so he did something against the governance or the policies, but it was with no practical effects. What would happen?
Perfect. So what would happen is whatever shareholder that didn't want the decision to go through, that shareholder, there would be someone to create a claim and say, this never should have gone through, even if there are no damages. This was an unauthorized transaction and it should be unwound. Right? This decision should never have gone through. And this is just a shareholder has to have standing. We have to have someone who's going to allege that something has happened. And usually that shareholder will only be making an allegation in court if they've suffered a loss and they're looking to recover. But in other cases, that shareholder could say, I don't like the direction of this company. Elon Musk never should have voted on that, for example. Let's say that they did. We should undo that decision, and the court should come in and give equitable relief. They should decide that that transaction was actually an unauthorized transaction and should be unwound, or there should be some other resolution.
No, but okay, but assuming that one scenario is when you have an express provision in the governance of the company saying you can't vote in this situation, but assuming now that you don't have this express provision, but it's based in the U.S. corporate practice, you are supposed not to vote on that, and you do vote on that, and there are no damages, but you are potentially conflicted and should not vote. And what would happen? And also the same thing, or?
Yeah, I mean, again, it depends. If it's a controlling shareholder who had a duty, then they may suffer, some action. They may be responsible. If they're a minority shareholder who was conflicted, when you say what should happen, you mean what happens with the decision or what happens to the shareholder?
Shareholder.
Nothing. I mean, the minority shareholders don't have themselves duties to other shareholders. They're not going to be responsible, so there won't be a decision against them. They're not going to be liable. The question is whether their vote would just be discounted.
Thinking about the controlling shareholder.
So then so that if the controlling shareholder should not have voted but did vote, then a court would decide, well, did that lead to damages to somebody, or should they be in some ways sanctioned because they breached a duty?
Breach the duty. Okay. Yep. So it's a much lower penalty that would apply in this case because you don't have damages. So
exactly,
it's not something that you should really
worry about as much.
Worry about as much. Yes.
It's strategic. It's exactly right.
Yeah.
And
and another thing that you said that I want to understand is the authority that the chairman of the shareholders meeting has. For example, typically I understood that he's not supposed to prohibit any shareholder, from voting. But aren't there cases foreseen in your law saying that in this case you cannot vote? For example, approving its own accounts. This is because the accounts should be right or wrong, they're correct or not correct, and we don't want to hear this from the one who made the account. So how it works, in case he goes to the meeting and votes in favor of the accounts, is he supposed, the chairman is supposed to register this vote?
So specifically with accounts, we actually have also stock exchange rules that require certain shareholder approvals. It's really a very small list. It could be an increase in capital. Your list was very good, Nair. But I think the accounts are actually very important because all shareholders need to be able to vote and effectively ratify and accept audited financial statements. So the account, they always have,
including the ones who made them.
Well, when you say who made them, so we would usually say management prepares accounts. They must, at least in the U.S. public company context, submit those accounts for external audit. There's an audit committee who has to select the auditor and approve the auditor, and then they need to submit those audited financial statements to the shareholders, and it must be approved by the shareholders.
No,
and
the problem is, okay, you have big corporations in the US, and here the point is that in Brazil we have a lot of companies controlled by families,
yes.
and typically the CEO is also the controlling shareholder. And maybe he owns a legal entity that owns more than 51% of the votes.
Yes.
So he was the one who made the accounts, and also is the one who approves the accounts. So, but I think you don't have maybe this is not a good example. So let's think about another example. You have a shareholders agreement filed with the company saying that shareholders could not vote in this, that, or that resolution, and they shows up there and vote. What does it happen? The chairman is supposed to register anything and everything, and the court will decide after that? Or,
yes.
Oh, really?
Well, yes, but the really great question you're putting here, which is a huge debate right now, is what gets on the slate of votes. It's before the chairman is just doing something very administrative, but the actual slate of decisions to be voted on needs to be circulated to shareholders with 30 days advance notice. I mean, there's a whole process about proxy voting and the amount of time before an actual event. The chairman of the actual shareholders meeting effectively just ratifies moments as they go, but there is actually a really interesting debate going on where you have activist shareholders who are coming in to these meetings, and they could try to present new issues to be voted on, or they could make these allegations in the moment. The chairman is really in a mode of not deciding who comes in and who comes out necessarily. But one of the big question marks we have is what happens if an activist shareholder tries to influence decisions, or maybe makes a certain allegation that a shareholders agreement item should not be voted on, should be voted on, and the chairman doesn't have really the authority. Usually, in a lot of this is in the bylaws of the particular organization, right? Delaware gives a lot of discretion of what goes in the bylaws and what a chairman of a shareholders meeting will actually be doing in practice, but it won't be ever effectively considering certain shareholders ineligible or conflicted in that moment. I think, at least in practice, Nair, you would see this all in litigation afterward, after the fact.
Okay, so I think his power is, okay, understood. And you mentioned abuse of the controlling power versus this discussion. And in fact, we have the Brazilian corporate law rules in detail, the abuse of the controlling power. And to tell you the truth, I think is absolutely the same thing that you have here. The same thing, because what you need in Brazil to characterize the abuse of the controlling power, you need an act practiced by an abusive act practiced by the controlling shareholder, damage, and a connection between them. It's only that. Okay. You need that. So it's extremely similar to this, and the damage element is fundamental. You said that not really there about considering damage in a fundamental element, but I think you are, because in the end of the day, when you go to court, if you're talking about, oh, you didn't observe this provision of our policy of blah blah blah, and the resolution or the transaction was fantastic for the company, I think this will be minimized or ignored, or nothing relevant will happen to this shareholder. So we are talking about damage all the time. I think
that's true. In practice, and now you're exactly right, because ultimately you can have a completely conflicted transaction that could seem unfair, but as long as it works out well, nobody's actually going to come and challenge it. Those decisions will stand from a corporate law perspective, even if legitimacy might be questioned in the future. But sometimes, what we end up really splitting hairs on, because this is why we don't think about the damages in advance, but when boards are going to take a risky decision, that's where they get 6 fairness opinions. That's where they come in with the independent committees of the board to have all of these mechanics. And even with all of those mechanics in place, it could actually be a completely legitimate transaction from a corporate governance perspective, but still absolutely subject to litigation. So what we always obsess around, what our scholars focus on from a jurisprudential perspective is, when will a particular decision be really will survive a motion to dismiss in court? When will it actually go to a judge to decide whether there was actually an unfair decision being made, or it wasn't an entirely fair decision in the interest of the company? Were there breaches of fiduciary duties? Were there conflicts of interest? Exactly like you say, ultimately, if there are no damages, and in fact, it was a great transaction, you never actually see this side of the corporate governance scrutinized and questioned. But it is actually, always very prudent for our clients to say, wait a minute, I need to protect myself, because it seems like a great idea. We're going to sell the idea. But ultimately, if there are damages, we all know that this will be scrutinized. And so we need to protect ourselves, hire good counsel, hire investment banks to give fairness opinions, and really try to help determine, whether this is something that should be presented for approval or not. Again, the conflict of interest point is a really interesting one and a hard one, because you're all thinking about it in the context of damages, which is an economic output, or that's an economic kind of evaluation. It's less about kind of the theory of duties, and the theory of whether I actually could have a conflict in play. It's a governance issue versus an economics issue. We in the U.S. always think about it, try to focus on the governance, and focus on the duties, but ultimately we only get this scrutinized when there's an economic outcome. For the Brazilian system to focus so much on the economic outcomes is so interesting.
Yes, and in Brazil, I think this decision, the CVM decision, was also influenced by a recent law that we have. Is called economic freedom law, and based on which you have to assume that everybody's making business, playing with, they have good faith. That you have to assume that everybody have a good faith. Not acting to take advantage of it. If you are in a resolution where you have a potential conflict, why should you assume that you take benefit of that in opposition of the company's interest, and my benefit in opposition of the best interests of the company? You can't assume that. I'm acting good faith. So, and most of the people, you have to assume that are good people, So I love this decision. I love this swift here from the CVM. And what else
well, should we see if we actually have other questions from anyone in the audience?
Yes,
Wonderful. I know it was a very rich debate here, and I think there are a lot of, I don't know if anyone in the audience would like to put into the chat or ask us if there are any points. I actually think that you might be individually able to put up your hand or unmute, but I know we are just at the top of the hour. I'm not sure, Kawe and Maria, if we should continue a bit or see if there's anything further.
Yeah, this is a wonderful discussion. I am loving it. And of course, we're open for questions. So if anyone wants to make a question, discuss any specific topic, you can write on the chat, or you can just open your microphone. It's everything is very open. So let us know. Otherwise, I can make a quick question to Nair, which I think is is the biggest challenge now, because so does anyone have a question?
Covered a lot of territory. All right, Kawe, we'll go with yours.
So let me make a final question, Nair, and then you
Yes.
can, and of course, David can also comment. So with the change in the CVM position, how does it change in practice on how shareholders should, consider? So how does it change how they approach a vote? Because before in the formal theory, it was very clear. If you have a conflict, it's better not to vote because it's going to be a problem. Now you can vote. So how should you approach this new possibility? How should you evaluate the risks? Should I vote? Should I not vote? Should I, is this a relevant enough decision for me to risk voting and have a question later? So how does it change the evaluation of the risk?
Sure. One point before that, hearing from David, it was clear to me also that we have a different situation also in Brazil, where due to the activism there, maybe you have a lot of minority shareholders that are ready to take a decision on complex matters. We don't have this same feeling here in Brazil, and you should have this experience, Kawe, when with your clients. Sometimes you have a complex decision to be taken in a shareholders meeting, and in case the controlling shareholder does not vote on that, maybe the other shareholders are not prepared to vote on that. This is one point that only is different, that a different situation that it may be very strong here, and if not, maybe it doesn't happen in US. But answering to your question, I understand the following. The shareholders should be sure that that resolution will not cause any damage to the company. This is a central point. But in order to protect himself from any any minority shareholder that can argue that was not good for the company, that there were other possibilities. The governance is the answer. The governance, I think this is very important, and it was very present in these two decisions of the CVM. So transparency, information, comparisons, decisions of internal committees, policies, internal policies. This will protect the shareholder and the company also, because if you're going to challenge a resolution that was very good for the company, you're going to cause problems to the company as well, not only to the shareholder. So I would recommend that. But depends. Each case is one case. Each company is a specific company. You have to think about. Sometimes you may adopt a strategy of, should I vote? Should I not vote? What do I do here? You can, maybe you open the shareholders meeting with the controlling shareholder and the management, explaining how good it is, and asking if anybody has any concerns and questions. And after that, they let the minority shareholders vote. In case they approve the transaction, you can refrain from voting, and that's okay. You don't need to vote. Okay, but you all have to bear in mind also that this will be considered in the future. This will be a precedent that in the future you'll have a similar situation, and maybe everyone will expect you to refrain from voting. And then the CVM will say, oh, why did you behave like this in this situation and behave like that in this other one? What happened here? So I think this would be what I would think about in a practical situation.
I just wanted to compliment this. I think a fantastic set of observations Nair provides, and even in the beginning of your observations there, Nair, I have to say the U.S. market is very, very minority shareholder obsessed when it comes to potential risk. Class action litigation continues to really drive what information gets shared, not just in kind of securities offering documents, but also board materials, proxy voting activity, and shareholders have a ton of power and really a ton of expertise. And I think that the Brazilian market continues to really evolve. We've seen so many new companies go public, at least in the boom of 2021, which is great because I think the more public companies we have in Brazil, the more of a track record, the more experience the market will get with governance limitations that are appropriate, but also shareholder protections that are appropriate. So there's always that balance. You want to make sure that minorities are protected effectively, but that they don't get in the way of certain strategic decision-making at the company level. And it's a very live and rich, debate. Conflicts of interest, continue to be litigated in many ways. I think more on these terms that I was mentioning of who controls in effect and when controllers should be required to step down, and where shareholders' interests might actually stop being just about money, profitability, shareholder value, dividends, and be more focused on policy value, ESG concerns. So this is a super live debate. It'll be really interesting to see how this new decision, the CVM, I think, or this position starts to get interpreted. So we look forward to participating with many of you in the debate going forward.
And I hope so. I hope that this decision remains valid for the next 20 years at least, and they don't change again back to the formal theory, because I don't like it at all. And I think that your experience in US is in favor of material, conflito material as well.
Exactly.
Okay, fantastic.
Perfect.
Any more questions? I'm so sorry when Cauê wrote here, let's open for questions. I didn't read it. I was so enthusiastic about the discussions here with David.
No, and it was a really interesting debate, and I would give one more minute to see if everyone. We still have a lot of attendees, which was also great. That shows how interesting was the matter that you brought here. I don't know if anyone has still any questions. If you're shy, we still have the Q&A open. If you have any if we don't have any questions, Nair, David, if you want to do your final remarks, and on behalf of the New York State Bar of the Brazil chapter, we are really happy to see so many attendees to this morning. And we have our monthly events, and this was certainly one of the best ones. So thank you again for putting together, Tiffany, also for your effort to help us. And if you want to give your final remarks, and thank you all for joining us.
I only want to say thank you so much, and thank you, Cauê, thank you, Maria, thank you, Tiffany, for all support here. And David, it was wonderful talking to you. I learned a lot. It was amazing, and we could be speaking here for hours. Fascinating. Thank you so much.
I'd say exactly the same thing. And I think this is exactly what the New York State Bar Association is all about, finding these really interesting cross-jurisdictional perspectives. So please reach out to Nair, please reach out to me with any kind of follow-up questions, even if you don't want to raise them now. And again, I think we'll all be watching this space very carefully, because it is always a bit of a moving target. But thanks so much to Nair, really, for the inspiration here. It was fantastic and a brilliant intervention.
Definitely.
Thank you all so much.
You raised the bar. Thank you all for
you.
Joining us this morning. Looking forward to see you in the next events. Cauê, I don't know if you want to say anything else.
No, I just want to thank everyone. It was an amazing event. Thank you for our panelists, and thank you for everyone that joined us.
Thank you. Have a nice day.
Thank you. Have a nice day. Thank you.
Bye-bye.
Bye-bye.
Bye.